Hi, I'm Siobhan, your Sales How-To Gal. This is the Ethics and Bar Rules module of Rainmaker's training. We're in Lesson 1, Matching the Tools to the Rules. Earlier in this course, we had an entire module entitled Leads and Opportunities. That's when you discover the tools or activities that are available to you to market and sell your legal services. Now we're going to take a look at the bar rules that apply to this sales and marketing activity and make sure that the strategy that you've settled on and the tools that you've decided to deploy are ethical under your state's bar rules. The rules you want to focus on are those dealing with niche marketing, advertising, referrals, fee splitting, solicitation, conflicts of interest, delivery of non-legal services by attorneys or legal firms, and the geographical limitations on legal businesses. Don't worry about writing those down now because they're going to be brought up again in more detail later in this lesson. But these are the activities that the bar restrains in various ways and to varying degrees. When evaluating whether your proposed activity is impeded or prohibited by the rules, keep in mind the purpose of the bar's regulatory scheme in general, as well as the purpose of the particular rule being analyzed. Because understanding why the rule or the rules were written will help you to interpret and apply them in practice. Let's look first at the general purposes of the rules of some of the larger state bars. To compare apples to apples, we're only going to look at unified bars, where attorney discipline and attorney and public services are carried out by a single entity. I'll start with the Florida bar, whose core functions are, and I quote, to regulate the practice of law in Florida, ensure the highest standards of legal professionalism in Florida, and protect the public by prosecuting unethical attorneys and preventing the unlicensed practice of law. Close quote. So that's your East Coast representative state. Now let's move up north to Michigan. Michigan's mission is, and again I quote, to aid in promoting improvements in the administration of justice and advancements in jurisprudence, in improving relations between the legal profession and the public, and in promoting the interest of the legal profession in this state. Close quote. So, now in my words, Michigan wants to improve legal process and the science of law, improve relations between lawyers and the public, and promote the legal profession. That's a succinct and clear mission. Now let's head to the West Coast. The State Bar of California's mission is, and I quote, to protect the public and includes the primary functions of licensing, regulation, and discipline of attorneys, the advancement of the ethical and competent practice of law, and support of efforts for greater access to and inclusion in the legal system, close quote. So this is the first of the states I've talked about whose mission mentions the word access as central to what that bar wishes to address. Finally, let's go down south. And this one may be my favorite mission statement, the mission of the State Bar of Texas, which, and I quote, is to support the administration of the legal system, assure all citizens equal access to justice, foster high standards of ethical conduct for lawyers, and enable its members to better serve their clients and the public, educate the public about the rule of law, and promote diversity in the administration of justice and the practice of law. Close quote. That is an amazing mission, a very progressive mission in a southern state. I've never practiced in Texas, but if they actually follow that mission, they get it. Now, why did I give you so many different mission statements when you're probably not admitted to all of those bars? I did that because when you're evaluating whether a proposed sales and marketing activity is acceptable, you want to start by evaluating how strict or progressive your state is. And I wanted you to hear what a strict or conservative state mission sounds like, say in Florida, compared to what a progressive mission sounds like in Texas or any of the other states that I mentioned. If you're thinking, well, my firm practices in many states and the same activity could be viewed differently compared to local standards, then you're right. That's what happens in our profession because it's a state by state regulation, except when the Supreme Court steps in. And in lesson 2 of this module, we will cover some of the Supreme Court cases where attorney rights are equal across the 50 states. For now, let's continue to evaluate on a single state basis, where all of your activity is confined to a single state. While Florida's mission statement argues for a strict construction against sales and marketing activity, the Michigan, California, and Texas mission statements suggest a liberal construction of the rules relating to sales and marketing. Those states seem to want attorneys to be creative in meeting consumer demand for legal services, as long as the attorney outreach or selling activity is not misleading or distressing to the public. Some sizable state bars that are not unified include the state bars of New York, Pennsylvania, Illinois, Ohio, and New Jersey. These are large bars. What about those voluntary bars? That's what they are, where the sole functions of the bar association are to promote the profession and meet consumer demand, while the disciplinary function is run separately by the courts. In those states, it may be more difficult to use the purpose of the bar for predictive value on how a disciplinary board may view the activity, but you should check the preamble to the rules of professional conduct to see whether it sheds light on the purposes of the rules and any responsibility that the courts place on lawyers to foster access to justice and or to educate the public about the rule of law. If the disciplinary rules provide that access and education are important, then societal benefit may be taken into account in analyzing the propriety of sales and marketing activities. If there's no relevant language in the preamble, just skip to the next step in the analysis. And that second step is to evaluate the purpose of the individual rule implicated by your proposed selling activity. The specific rules you want to isolate are listed on this slide. Look at your state rule on fees. That's Rule 1.5 in Florida. In particular, what does the rule say about sharing fees, splitting fees with attorneys from outside the firm, and splitting fees with non-lawyers? 3 different things. Next, what does it say about referrals? Can you pay someone for undertaking the sales function? Referral fees are strictly prohibited in Florida under Rule 7.17. Can you give your non-lawyer staff a bonus for referring a client, similar to bonuses paid to staff for referring an employee? In Florida, the answer would seem to be no, again under Rule 7.17, which prohibits the provision of money or other tangible benefits to another person for procuring work. And another person is the language used there. So it would seem that any person, regardless of their employment status, would be a prohibited person to receive the money or benefits. This rule expressly exempts regular compensation paid to an assistant for preparing an advertisement, but does not mention or exempt bonus compensation. So it seems to be pretty clear there. And that's unfortunate because in a good business, every aspect of the business impacts sales. Client service is the greatest influencer of sales. However, community involvement matters to some prospects. The way your employees speak about you in public, including on social media, is part of your marketing, whether you intend for it to be or not. So you're going to need to put your thinking cap on if you want to incentivize employees, including non-lawyer staff, to promote your business in the kind of light that can attract prospects to it. Moving on, do your state's rules say anything about value billing? For example, if you charge a client based upon the amount saved or generated, rather than the amount of time it took you to do the work, would your state view the fee as excessive? How could you document that it's actually market value based, for example, on what management consultants or other experts charge for similar advisory work? So you have two arguments here. One, the fee is not unreasonable, and two, the work is not legal work because, for example, a law degree is not required to do it. And that's the next rule we'll be analyzing, the rule regarding the provision of non-legal services. So for now, let's focus on the fees and the reasonableness arguments about the value billing. Reasonable compared to what? That should be what competitors charge, right? The Florida rule appears to allow value billing because one of the factors taken into account in determining reasonableness is the fee customarily charged in the locality for legal services of a comparable or similar nature, legal services. Your competitors happen to be non-lawyers, but who performs work is not determinative of its nature as legal or non-legal work. So you should be able to charge what other providers charge. Now we can move on to how your state regulates non-legal services provided by lawyers or law firms. In Florida, that's Rule 5.7. In your marketing and later in the engagement letters, consider whether you need to separate services requiring a law degree from services that don't. Lawyers are not prohibited from offering non-legal services. Rather, the rule is concerned with whether the client believes that the non-legal services are covered by attorney-client privilege. If so, your sales and marketing activities with respect to non-legal services are going to be limited to activities that you could undertake when selling legal services. They're going to make you treat the non-legal services like legal services if your client or prospect believes that the activity is covered by the privilege. If your prospect doesn't think these services are covered by the privilege, then your sales and marketing activities with respect to those non-legal services should not be subject to the bar limitations. I have a brokerage business in addition to my legal business, and my clients know that brokerage services are not legal services and they're not subject to attorney-client privilege. In fact, I have to tell the other side certain information about the item, the property that they're buying. So in that instance, I can market those services without being subject to the bar rules. Now for an example where you might not get the same favorable outcome I just got. Say you offer corporate tax planning services and you employ a staff to prepare corporate tax returns. In that instance, the compliance work is not distinct from the legal work, and the selling of both services will be subject to bar rules. The next rule we're going to look at is the conflict of interest rule. From a selling standpoint, you're interested in the conflict rule relating to concurrent representations. Does it restrict your ability to represent a group of clients with similar, though not identical, interests? What safeguards are required? In Florida, the rule is 1.7. If you're in a different state, pull up your rules online and search the term concurrent. So do a find for the word concurrent. What you'll find is that concurrent representations are permissible if clients all give their informed consent and the lawyer reasonably believes that she can provide diligent representation to each client. Another potential interaction with the conflicts rules is if you serve a particular niche or industry, which of course I've encouraged you to do. It's easier to sell if you're selling to the same clientele. In that case, you likely will find yourself representing competitors in successive engagements. The duty to former clients may be raised here. Remember that the conflict of interest rules are designed to protect clients when they are represented by the same attorney and their legal interests are directly adverse. The rule is not designed to protect clients from general business competition. Therefore, You can provide advisory and other services to competitors as long as confidentiality is preserved. Moving on to niche marketing. This is where you emphasize certain industry or subject matter expertise. There's likely a rule about use of terms specialist or expert in your marketing. The rule may be coupled with a discussion of certifications if your state bar issues certifications. In Florida, the rule is Rule 7.14 regarding potentially misleading advertisements, and the goal is to ensure that the advertising is truthful and not misleading. That's the purpose of that rule. Explaining the amount of related experience you have, any specialized degrees you hold, or the percentage of your practice that's devoted to an area are ways to ensure that your niche marketing is truthful and not misleading. Moving on to solicitation, Rule 7.18 in Florida. This is an area that may be more difficult to plan around. The ABA Model Rule 7.3 was substantially revised to permit the contacting of business prospects who routinely use legal services of the type that the lawyer is selling. However, Florida has not adopted that approach. Florida does not distinguish between business and individual prospects and prohibits all but male contact with persons the lawyer is not related to and does not have a prior business relationship with in the lawyer's capacity as a lawyer. The comments to the Florida rule provide little insight into the harms that the rule is designed to protect against. However, more liberal Michigan has a rule almost identical to Florida's rule, and the Michigan comments disclose the Michigan bar's concerns that lawyers may overwhelm or unduly influence clients at a time when they're vulnerable because they're faced with a legal problem. Oddly, however, even though the Michigan bar's concern is related to B2C, business to consumer solicitations, there is no exception in the Michigan rules for B2B, business to business solicitation, where there's no imbalance of power between the lawyer and the business executive or entrepreneur. See, these people regularly evaluate sales pitches from all types of providers whose services they may desperately need. And they're almost certainly being approached by many different lawyers so they can decide which lawyer they want to work with and which one they don't. Now, if you're a student of legal reasoning, then you remember the axiom that where the reason for the rule stops, there should stop the rule. But that isn't the case yet in either of these jurisdictions. Now let's talk about jurisdiction or geographic constraints on lawyer prospecting. Before we get into the minutia, it's important to point out that currently, bar rules generally apply to individual attorneys and not businesses because law licenses are issued to individuals, not companies or firms. Can a non-law firm business market and sell legal services across state lines into jurisdictions where its attorneys are licensed? Sure. Now, the bar rules do not directly address the issue, but we all watch television and surf the web where we see advertisements for legal services from LegalZoom and other providers not domiciled in our home state. So, what if you or your law firm are running ads on TV and you're located in a television market that covers 2 or more jurisdictions? That would be true of lawyers who practice in northern Florida or southern Alabama, that Mobile, Pensacola market, for example, or someone located in Maryland, Virginia, or DC. Probably also true of the Philadelphia, New Jersey market. There's that Cherry Hill right there close to Philadelphia, across the Ben Franklin. Some states, including Florida's advertising rules, extend to law firms, even though the license is not issued to the firm. I'm guessing the threat there is to penalize the partners of the firm for any transgression. You should see Rule 7.11 there. It's not likely that the advertising rules are uniform in all the jurisdictions where your messages easily may travel. This suggests that advertising activity should be evaluated under the laws of each jurisdiction whose residents you're targeting. What about selling activities other than advertising, such as media appearances on national news, opinion, or entertainment programs? You see the person giving legal commentary on Fox, The Morning Joe, CNN. Or what if you, through your legal entity, offer a contest on the internet as a tool to identify businesses in need of your services? Must you limit the winner to businesses domiciled in your state? Florida's rule on multi-jurisdictional practice of law is Rule 5.5. It states, with obvious exceptions for infrequent pro hoc vice appearances, that a lawyer cannot practice law in any jurisdiction except her home state, cannot hold herself out as practicing in Florida, and cannot open an office or establish a regular presence here. And that term, establish a regular presence here, is not defined. The comments to Rule 5.5 are instructive regarding the harms the rule is designed to protect against. The comments say that limiting the practice of law to members of the state's bar protects the public against rendition of legal services by unqualified persons. The balance of the comments focus on the work being performed in the jurisdiction rather than the non-advertising selling activities employed to generate the business. The comments, like the rule itself, do not include a definition of presence in the state of Florida. To answer that question, you need to do legal research, not only of ethics opinions, but also of those long-arm statutes and federal and state constitutional law cases. Now, the bar and general authority may be opposite in their conclusion because the bar often explains its position, how it views the activity, and then leaves it up to the attorney to locate any opposing authority or viewpoint. Unless I found something that indicated that state law somehow prevailed, I would document my file and move forward with the proposed activity. As I will discuss in the second lesson regarding regulatory trends, there are some states that are considering wholesale regulation of entities that sell legal services. If your state adopts such a rule, then all bets are off, and your firm would need to rethink or reanalyze the consequences of all types of marketing, including but not limited to advertising, in your home state and any other jurisdictions where your messaging is delivered. Now, let's talk about advertising within the jurisdiction in which you're admitted. Virtually every state bar provides extensive regulatory guidance on advertising. They don't like advertising. This may be because it's one of the most common forms of prospecting employed by attorneys, or it may be because there's been litigation and published cases, including from the U.S. Supreme Court, restricting state bars from impeding this commercial speech. That case law includes the seminal case of Bates v. Arizona in 1977 relating to print advertising, or the Shapiro v. Kentucky Bar Association case in 1988 regarding mail advertisements, which also qualify as written solicitations. So the state bars have been admonished by the Supreme Court and have softened the rules to comply with Supreme Court precedent. And lately, it appears that some states are interested in further softening beyond the minimum required by the Supreme Court. The focus of advertising rules is the prevention of false, misleading, or unsubstantiated advertising. Puffery is not something that's allowed in legal advertising. You also may not be able to include testimonials on your website or other advertising medium if the client received a discount or anything of value in exchange for providing the testimonial. This conduct is prohibited in Florida by Rule 7.13. So check your local rule to see if you have to announce that they received a discount or if you just can't use it at all if they received a discount. Moving on to the next slide. This slide is my evaluation and opinion regarding the degree of interest and regulation that the various state bars placed on individual selling activities, and the ease or difficulty with which a lawyer or legal firm can organize its affairs in order to bring itself within the rules while engaging in the activity. My rating scale doesn't relate to the number of rules or the length of the rules. Rather, it relates to the perceived aggressiveness and resolve of the state bars to prevent the activity from occurring. 10 means there's a great deal of restraint and considerable difficulty avoiding the rule. 0 means there's little restraint or difficulty. While the section of the bar rules devoted to advertising is quite long, the rules provide safeguards and boundaries rather than expressly prohibiting commercial speech. By comparison, the rules relating to solicitation are short in length, yet highly prohibitive. There's also zero tolerance for sharing fees, especially with non-lawyers. So if your sales strategy is trending toward the heavily regulated behaviors, you're going to want to carefully review the rules, the ethics opinions, and the court cases in your jurisdiction. Craft your sales strategy around the hurdles, and then document your analysis of why you believe your proposed activity is compliant. So let's stop and summarize the analysis now. After you prepare a draft lead generation strategy detailing the tools you want to use in your business, you must identify the rules that apply to those proposed selling activities. Number 2, next, identify the overall purpose of your state bar rules, either in a unified bar's mission statement or in the preamble of the rules of professional conduct issued by a disciplinary board of a state that does not have a unified bar. Have you prepared your strategy in a way that fosters greater access to justice, or that provides information to the public that the public might not otherwise have about their rights and responsibilities under the law? Are there other ways that your proposed activity benefits society in the ways that your state bar has indicated are important to the state and that are considered part of the role of attorneys practicing in that state? Are your communications clear and not misleading? Number 3, discover the purpose of each individual rule that governs your proposed conduct. This purpose can generally be found in the comments to the rule. What in particular is the government trying to protect against with the rule? Will your conduct cause the harm or danger the government wants to prevent? Next, in your analysis, if the activity you intend to conduct is not clearly within the rules on their face, review the ethics opinions and the court decisions relating to the planned conduct. Does it appear that the rule was designed to protect the legal profession from competition more than to benefit society? And that's the case often with our rules, I'm afraid. If so, how have the courts in your state or the U.S. Supreme Court ruled on such cases involving your state bar or your state's rules regulating the bar? For example, has your home state Supreme Court ruled that non-lawyers can perform basic legal services, or that certain services that arguably appear to be legal services are not in fact legal services? If so, that case law may provide insight into how the court would view the activity you are contemplating. If you believe your activity would withstand a challenge by the bar or a competitor who wishes to prevent you from engaging in the activity, you should weigh the risk and rewards, including contacting your insurer, if any, to determine whether you have coverage or could otherwise bear the cost of any resulting litigation. Number 5 in your analysis, if you feel comfortable that your conduct is not prohibited, document and rely on your analysis of why your conduct fits within the letter and spirit of the law. A well-documented file is helpful to prevent or mitigate any discipline and to guard against denial of coverage by your insurer, if any. Analysis. If you are unsure that your proposed conduct is not prohibited, after reviewing applicable precedent, consider getting an ethics opinion. You can obtain a legal opinion from qualified ethics counsel. Such an opinion would serve as further evidence of the process you undertook for purposes of avoiding or mitigating discipline and preventing denial of coverage by your insurer. A legal opinion that your proposed conduct is ethical also may bring the ethics attorney's malpractice insurance, if any, in play as a potential source to recover any damages sustained as a result of the disclosed proposed activity. The activity you told that attorney about and that he opined upon may bring into play his or her malpractice insurance, if any. The other option, of course, is to seek an opinion from the bar. This has risks as well. What if the bar simply doesn't like your activity, even though it's not prohibited? A person's feelings about behavior sometimes can color their analysis or advice. And if you disclose the proposed conduct and they view it negatively, a challenge is almost assured, right? So you have a decision to make. Do you seek permission or forgiveness? It's a judgment call, and no one can make it except you. Number 7, the last step prior to executing your sales strategy is to make any adjustments that your research or opinions indicate are necessary, and then update your file, documenting how you arrived at your now revised sales strategy. Finally, let's end with a hypothetical. It's from a television drama called How to Get Away with Murder. The show had a lawyer protagonist called Annalise Keating. If you watched the show, you know that virtually everything Annalise did was unethical for the entire 6 seasons of the show. She was a proverbial hot mess and a badass. So, we're going to use an example from one of the episodes that involved prospecting. We will identify what Annalise did wrong and what the rules required her to do. Then we're going to do something forward-looking. We're going to analyze who got it right, the bar or Annalise. In other words, did the bar rule do more to promote access to justice, to educate the public about their rights and responsibilities under the law, and or to provide a societal benefit, such as equality under the law, or did Annalise's actions do more to benefit society? So who got it right? Here are the facts. Annalise is at a prison visiting a client. While there, she approaches other inmates who are not her clients and informs them of her intention to file a class action lawsuit that could get them new trials based upon ineffective assistance of counsel due to the public defender's lack of funding and staffing, man-hours, necessary to adequately investigate their cases and prevent the best defense for them. So she's seeking to replace their public defenders as counsel, and she wants to put the system on trial, right? Annalise had no prior relationship with these inmates. She found them in a database, then approached them with the opportunity. Soon, her demand for plaintiffs exceeded the number of inmates that she could discreetly engage at the prison by herself. So she enlisted the help of a police friend whose father was a member of the class. She asked the cop to help her sign more inmates. Though I don't recall money being discussed during the episode, Annalise was not an independently wealthy person. So let's assume that a contingent fee would be earned by Annalise if she succeeded with the class action. So those are the key facts. Viewing that conduct strictly from a sales and marketing lens, what did Annalise do wrong? In other words, let's not focus on non-sales activity that may have violated a rule. We're looking solely at sales activity, sales and marketing activity. In Florida, the applicable rule is 7.18, direct contact with prospective clients. Unless the lawyer is a nonprofit, Rule 7.18 prohibits in-person solicitation of prospects who are not related to the lawyer unless the lawyer has a prior professional relationship with the prospect in the attorney's capacity as a lawyer. That's a pretty comprehensive rule. Asking strangers to be their lawyer is unethical under that rule. Rule 7.18 also prohibits the use of a third party to do that which the lawyer could not personally do. So enlisting the cop also was unethical. Annalise's conduct, therefore, violates the letter of the law. What do the rules require under these facts? What should she have done? The lawyer is required to send the prospect a letter, clearly marked as an ad or a solicitation. Now, since these prospects are inmates, they don't have ready access to a phone or a mailbox and will have difficulty timely responding to a letter. Why else would a letter have been ineffective in this case, an ineffective way to solicit clients? For this, I have to give you some additional facts. Annalise had a small legal practice that was supported by student interns from the criminal law course Annalise taught at the local law school. Therefore, Alerting the government of a potential class action before she had her ducks in a row might have led to efforts to discourage inmates from joining the class. It also might have led the government to assign a large team to the case and begin building a robust defense that would have overwhelmed Annalise's two-attorney firm. Thus, she might have been crippled before she got out of the gates. But still, a rule is a rule, and it's there for a reason. What is the intent of the anti-solicitation rule? You'll recall from our early discussion of the solicitation constraints that the comments do not indicate how in-person solicitation is harmful. However, the Florida comments do say why written solicitation that discloses how the lawyer learned about the prospect's legal issue and how much the lawyer knows is the only acceptable form of solicitation. That comment says that the goal is to prevent prospects from being misled about the degree of knowledge the lawyer has about the prospect's matter. The comments also indicate that the rule applies even with respect to sophisticated or highly educated persons, including the lawyer's personal physician and attendees at a conference where the lawyer is a speaker. The rule and comments do not expressly exempt or make mention of business prospects or corporate executives. Remember, Florida is very strict. By comparison, the ABA Model Rule 7.3 on in-person solicitations expressly exempts communications with corporate representatives. The ABA Model Rule also exempts persons the lawyer has a close relationship with, even if such persons are not relatives, and it exempts individuals the lawyer has a business relationship with, even if the relationship is not in the lawyer's capacity as a lawyer. The states use the model rules in developing their own rules, so it must be presumed that the Florida Bar is aware of the ABA rule and has purposely not aligned itself with it. Florida legal consumers receive greater protection from, or less access to, depending on your point of view, lawyers than legal consumers in jurisdictions that have aligned with the more progressive ABA rule. Therefore, Annalise's conduct also violates the spirit of the law if she's in Florida. And in other states, maybe it doesn't violate the spirit of the law. Now, I said we were going to evaluate the justness of the rule as well. While the Florida Bar's mission statement is strictly about law and order and disciplining attorneys, the preamble to the rules is much more liberal. The preamble says a lawyer should seek improvement in the law, access to the judicial system. That's a quote from there. It says a lawyer should cultivate knowledge of the law and employ that knowledge to reform the law. And it says that all lawyers should devote professional time and resources to ensure equal access to our system of justice and to all those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. Now, returning to our example with Annalise, she was dealing with inmates who she believed might not have had an adequate defense because the public defenders had too many cases and too few resources. Some of those inmates may actually be innocent. All of them have been denied equal access to justice because they could not afford a private attorney. Now they have a private attorney of exceptional talent who's trying to reach out to them to educate them about their rights. It is a communication that they desperately want, and it's unlikely that a written communication could have effectively explained the issue and their rights, given their likely educational deficiencies. Most people in prison haven't had a great deal of higher education. Regardless of whether there's an opportunity to earn a contingent fee by suing the state, Annalise is seeking to reform the law. The Florida Anti-Solicitation Rule is intended to prevent individuals from being misled by the lawyer. But as long as Annalise does not overstate the likelihood of success of the suit or downplay any of the negative effects that being a class member could have, it appears that the law should be changed rather than the attorney being disciplined on these facts. Now, am I suggesting that you go out and violate the rules if doing so serves justice? No. To the contrary, I believe that people who are not involved in the sales process often don't fully understand the practical impact of the sales related rules they make. So, if you cannot find a way to work around a rule that's producing unintended consequences for legal consumers, you must work to get that rule changed. We'll cover rulemaking shortly in lesson 2 of this module when we talk about trends and regulation.